All right, welcome everyone to this week's Ethics Law and Society Forum. When you schedule these events, often 5-6 months in advance, you only hope that there is end up being as timely as today's talk is going to be. I should say that our originally scheduled speaker, Angie Young, had to cancel due to a scheduling conflict, but I'm thrilled that we have another expert here, Bernice Espinoza, to talk to us about recent developments in immigration law. With a law degree and a BA from UC Berkeley, Ms. Espinoza is a trial lawyer who has served in several public defender offices, including Riverside County and Contra Costa County. She's now, make sure I get this right, the criminal immigration specialist for Sonoma County Law Office of the Public Defender. In this role, she's on the front lines of immigration law and so well positioned to get us up to speed on what to me at least feel like a breakneck pace for developments in immigration law and policy. So please join me in welcoming Bernice Espinoza.
On November 9th, I pulled into the parking lot right behind the jail like I do every day. I sat in the car, turned off the engine, and I started to cry. Because I started to think about how nobody else in my office would understand what it was like the day after election when Prop 187 was passed when I was in junior high. And I was told, go back to your country. But I was born here in El Paso. And my dad was born here. My mom wasn't. She was a green card holder. And I got to see her get naturalized when she was trying to get a job, and the things and questions that she had to go through. How the interviewer told her she didn't even know her last name because she asked, do you want my name traditionally the way we say it in Mexico? Blanca Estela Enriquez de Espinoza or Blanca Espinoza? And he mocked her and told her she didn't even know her name. I sat in the car and I thought about the 600 students who were at the Santa Rosa Junior College undocumented student conference and what was going to happen to them next. I had just presented to them 3 days before about the intersection of criminal law and immigration. And then I looked to my left on the big brick building which houses my clients. And I thought about what's going to happen to those people who get booked for driving without a license and get notified to ICE that they're there. What will happen to their families? What will happen to my clients? And then I thought about, as days passed, what it was like to be a student right after 9/11 at Berkeley and being confused for being Arab American or Muslim, and standing in solidarity with other students breaking fast at Ramadan and hearing spiteful, horrible things. And then the raid started. And I worried about how people thought these things were deserved, how people didn't understand that this did not happen overnight, that there has been quotas that allow a certain number of people from all countries in. So tiny little Belgium has the same amount of people who are allowed in as huge India, and how geopolitics are completely ignored. how the colonization, either literally or financially, has affected people wanting to come into this country, becoming economic or real refugees of war. And how there's been an increase of criminalizing immigrants and people of certain faiths. I knew in 8th grade I wanted to be a civil rights attorney. I never imagined that being a public defender that does immigration consequences would have been where I'd be now, at this time, in this place. And feeling for the first time, I don't get to learn about the civil rights movement, I get to be part of it. So how did we get here? This is a review of immigration law and the next phase of immigration law and policy. I'm not an immigration attorney. I'm a criminal defense attorney. In 2010, Padilla versus Kentucky was a U.S. Supreme Court case that said, criminal defense attorney, if you have a person who is not a U.S. citizen, you need to let them know what the immigration consequences of their criminal plea is going to be. And if not, we can take away your ability to practice law. And we can also undo that deal that you had. Because we see, as a U.S. Supreme Court, even with Scalia on it, that immigration consequences are not just collateral consequences, like not being able to live in HUD housing or not being able to vote. That it's a punishment, and sometimes a worse punishment than the jail time. So that's what I do, and we'll go through a little bit of the law that goes through up to where we are now. First, we'll give a little Immigration 101, what immigration under Trump presidency looks like, some of our state laws, and local advocacy and sanctuary movements that are happening around here. The immigration branches of government, and this is not a complete list, but just to give an idea, there's an executive branch that's headed by the U.S. President, and there's federal offices underneath them. There's the Department of Homeland Security, the Department of Justice, the Department of Health, and under that there's also the legislative branches and the judiciary. So there are 3 frameworks. The hyper-immigration enforcement didn't just happen as of January 25th. This has been in the process and actually started under President Obama. In the fiscal year of 2012, there was a record number of deportations, 400,009, and deportations were over 2.5 million under Obama's administration. That's more under that administration, the 8 years that were there, than all of the previous years collectively. And there's been $18 billion spent on immigration enforcement in the fiscal year of 2012 alone. So who's looking at being deported? It doesn't only affect undocumented people, it also affects people who have documents. So if you're here with a student visa, for example, some of the peers that are sitting with you in this room at this time may be visiting from another country and have status for that reason. If you're an asylee, a refugee, people with temporary protective status, for like the individuals from Haiti who suffered through the earthquake and had to come to our country. If there are certain crimes or certain police contacts that they have, they are susceptible of losing their status. For undocumented people, just being in this country, they can be removed. And there's different kinds of undocumented status. People who may have entered without inspection at all, just crossed over the border or came in from on a boat or whatnot. Their visa or immigration status may have expired, so came as a tourist or came as a student, and that time has lapsed. Or they were removed in the past. So there's a lot of confusion that being undocumented is a crime. It's not. There was a case that was litigated out of Arizona that made it clear that local law enforcement policies, I'm sorry, that's the next slide, but it's only a violation of civil law. Being physically present in the United States without status does not mean there's a criminal offense. It's a civil offense. It's subject to civil immigration proceedings, and there may be forms of relief that are eligible to stay in the country. So can local law enforcement agencies make stops or arrests for civil violations? No. Local law enforcement agencies can't stop someone just based on the suspicion that they're here in the country undocumented. This was after a result of a case, a law that was passed in Arizona, and it was found to be illegal to do such sort of stops to make local law enforcement enforce civil immigration law. It's also only allowed for local law enforcement to make stops based on criminal activity, and if there is suspicion of criminal activity, it can't be prolonged just to try to find out if there is some immigration investigation. So how does an immigration make contact with our loved ones? Airports and borders, trying to apply for immigration benefits such as green cards or citizenship, the DMV in different states, Amtrak, Greyhound, raids at home, work, and through the criminal justice system. And we will go through that a little bit more. The criminal justice system has been increasingly more used in the immigration context. This started, and we'll go through a map of what these things are, but the criminal alien program was first. ICE agents would interact with local and state jails to identify and screen people and see who's deportable. After that came the Secure Communities program. And then under Obama, November 20th, 2014, there was a form of administrative relief called Deferred Action for Childhood Arrivals, and a new set of priorities of which individuals were going to be focused to be removed, focusing on people who are terrorists and felonies, and what's called an aggravated felony as a level 1, the second level being people with DUIs or domestic violence, and then the last one being based on stopping at the border and entrance. After the executive order that was issued by President Trump on January 25th, 2017, we have returned to the Secure Communities program. So the criminal immigration pipeline, it shows that you get from arrest into my animation's not wanting to work. But we'll go on to the next slide. When a person is taken into custody, there's certain information that's shared. So a criminal alien program includes all kinds of operations to share information with apprehended people and with locally to federal agencies. So these are the list of things that are given: fingerprints, booking lists by jails, access to jail records, notice of release dates, and inmates' home addresses. This will also result in either an ICE hold or a notification process. Also part of the booking process is asking a person where they were born. So under the previous administration, we had Secure Communities, and then it went back to the Priority Enforcement Program. That's what we call PEP, and it's very similar. This is what happens. Person's driving along the street. They get pulled over. They're driving without a license. Person is then arrested, taken into the county jail to get booked. They are fingerprinted. Once they're fingerprinted, that fingerprint goes into a national database. And then, let me see if this pointer works. Okay. And once it goes into the national database, ICE gets a notification that, oh, this fingerprint matches with someone that we had for a visa. And so they'll send a piece of paper. And before in Secure Communities, it used to be called an ICE hold or an ICE detainer. and send it to the jail and say, please hold this person for us for up to 48 hours and we'll come and pick them up after they've been released. Under the priority enforcement program, same thing would happen, but instead now they have 3 forms called notifications. Please just let us know at least 48 hours before you release this person of when you're going to let them out of jail so we can come pick them up. The reason why the ICE holds don't exist anymore is because they were found to be unconstitutional. That's because a detainer is just an administrative document. It's done by an ICE agent. It's not a warrant, and it's only done by a person who is not a judge or a magistrate. And they also found that prolonging imprisonment in order for ICE to come over and pick a person up violates the Fourth Amendment. And that's in a few of these cases that I have for you. It started out with civil rights groups bringing cases against jails, and counties were found liable against civil rights violations for violating people by holding them after they were supposed to be able to go home. So in our area, in this county and in California and parts of Oregon, it is illegal to hold a person after the time that they're supposed to be released from jail. There was a decision just made on Friday, then Miami-Dade, which covers the 11th Circuit, that also said that it's unconstitutional there. Earlier in last fall, there was a similar decision in Chicago as well. So under the priority enforcement program, it took what was used to be an ICE hold, this little document says hold them until we get there, into these 3 different documents. They're all ICE notifications. They all serve the same purpose, to apprehend someone from the local jail and hand them over to ICE. So there's the immigration hold request, 247D. We haven't seen those in our county. That would need a signing by a magistrate to be enforceable. A 247N says based on the priorities under the Obama administration, this person has this kind of previous conduct, and so we would like to have them as soon as you're done. Since the executive order of January 25th, we've seen an increase of the last one, which is a catch-all custody request, the 247X saying, oh, they're of a federal interest to us. We're not going to tell you specifically the priority. It is an interest to us. Let us have them as soon as you're done. So how does this lead over to ICE raids? Well, with the information that's provided, like I said, a traffic violation, driving on a suspended license, a trespassing, taking candy from the store, shoplift. That little basic information is put in public records. Those records are then evaluated, reviewed, and people have taken that information from the federal government in order to get into the homes of individuals and do raids. So there's several ways that we mentioned about how a person gets in contact with ICE. One is the jails, but we also talked about other ways. In all of these systems, once a person is in contact with ICE, they are taken into custody, they're placed in detention. There's an immigration bond that can be placed, but oftentimes charges will not allow them to. A bond is different. In the criminal arena, in order to pay a bond, you can pay only 10% of it and then have your bail bonds person cover the rest. In the immigration arena, they have to pay the full entire amount. This, of course, impacts poor people. Immigration court is then, you're taken from detention into immigration court. You may have several times that you go through that. There's proceedings. If you don't like the decision from the immigration judge, it goes to the Board of Immigration Appeals. And then the circuit court, and finally the U.S. Supreme Court. This can take years. And during that entire period of time, a person may be in custody. And the difference between custody and a criminal case is that it's supposed to be punitive. And so there's different types of ways that we hold people in custody in the criminal context. However, in the immigration context, it's civil. And so some of the laws and protections that apply to the criminal world does not apply to the immigration world. And it's only supposed to help determine where a person is supposed to live. And I will bring up a note that only recently, in about the last 12 years, people who were not part of what's called a repatriation agreement. So, for example, some countries will not accept people that our country wants to deport. And Cuba's in one example of that. So what was happening before is they wouldn't have anywhere to place these people. If they were found what's called deportable and inadmissible, meaning they could have had a green card, had a simple possession of marijuana, that would mean that they would get kicked out, but they would have nowhere to go, so they were being detained inside of these detention centers indefinitely. That practice ended in around 2005. On any given day, ICE detains over 33,400 immigrants in 250 facilities across the country. This is more than triple the number of beds since 1996. That's an important number because 1996 is where we did get the increase of criminalization. It's the IRA. It's an act that was under Clinton that said, these are the individuals we are going to remove. These are the people we're going to say can't apply to have any status. In 2016, the U.S. had a record number of individuals in detention with 42,000 in custody. 60% of immigrants in detention are mandatorily detained, and that's what we're talking about. They can't get bond. Many of the facilities that are used for immigration detention are run by for-profit corporations such as CCA and GEO. Immigrants that go through the civil immigration proceedings have a lot less rights than the criminal law. So as you see on TV, and it says if you don't have, if you can't afford an attorney, one will be appointed to you. That's how my clients get me as a public defender. There is not such a right in immigration. So although they may have an attorney, it has to be purchased. And as a result, 85% of detained immigrants are unrepresented in immigration court. And for the longest period of time, this also included children who are 3 years of age were told they had to represent themselves. There has been some changes in that in recent time. So let's look a little bit at the most recent history of immigration law. After 9/11, there was an issue of national security. The Department of Homeland Security was established. There was a division that did special registration for people of Muslim faith or from certain countries. And they had the E-Verified, which is for finding whether or not a person's status is employed by the right people. So if you were undocumented, that was checked out by this E-Verified thing while you were trying to get a job. In 2002 to 2005, that's where my job kind of started happening more. The CRIM-IM is the short way where we talk about criminal immigration increases, and the Real ID Act was happened as well. In 2010, SB 1070, that's the Arizona law that was litigated, and now we have clear statements that local law enforcement can't impose civil stops and frisks and that sort of thing. SCOM, we just reviewed that. It started in 2007, and then ICE access programs that were called CAP and 287G that we reviewed as well. So I will go a little bit more into 287G in a few moments. These are special contracts with local law enforcement, and that is something that the current president wants to reestablish or expand. In 2011, there was a memo trying to establish what the priorities were going to be. And local and state responses across the country started rising to say, we don't want to have this secure communities program in our homes. It's separating people. It's not making us feel secure. and we want these programs to stop. In 2012, in response to a lot of that action, the President Obama made a memo and statement saying, okay, these are the outlining priorities we have, and we're going to also give a form of relief to deferred action of childhood arrivals. What is DACA? It's what we commonly also call dreamers. These are individuals who were brought here to the country before the age of 16, have been here from 2000, it's 5 years before 2012, so 2007 to 2012, they have to show proof of that. They also have to have other requirements about what their background is, if they are currently in school, if they've been to school. They can't have certain crimes on their record, and they have to show proof of all of these requirements. It takes quite a while to get the process completed. But it gives a work permit and an ability to stay inside of the country for 2 years. And 2013 is when we had a record high on deportations. And then 2014 through 2016, there was an attempt to expand the deferred action of childhood arrivals, not to these only few people, because there's some people who were brought here at 16 and a half. Well, it wasn't their choice to be brought here, but they still came here with their families and they couldn't apply. And also to extend it to parents of U.S. citizens, and the executive order was challenged in the Supreme Court, and because of a vacancy of not having the right number of judges, it was a 4-4 split. So it's basically that. Okay, so now where are things? The President has made several executive orders. The border security and immigration enforcement improvements, enhancing public safety in the interior of the United States. Those were both done on January 25th. And then the third, protecting the nation from terrorist entry into the United States. That was done on January 27th. The way that you can think of it as the first one is like build a wall. The Muslim ban is the last one, and the second one is deportations and border patrol. So the deportation campaign was part of the campaign promise happened that there was President Trump stated that he was going to deport 2 to 3 million people with criminal records. However, there really isn't 2 to 3 million non-citizens with criminal records. So there has been some statements in the executive orders of how they're going to reach that number. So any removable person, this includes people with green cards, who have been convicted of, well, let me back that up. People with green cards who are now removable. And that's a definition that we don't have time to get into. But if a person has had been convicted of any crime, who has been charged with a crime where it's still pending and going on, or has committed acts that constitute a chargeable crime even if it wasn't filed or dismissed. And in the judgment of an immigration officer, they're otherwise a risk to public safety or national security. Okay, as a public defender, people get arrested every single day. And every single day, those police reports get sent over to the district attorney's office for them to be reviewed, because police officers are not attorneys. And sometimes when reviewing those police reports, the DA says, oh, that doesn't exactly meet the elements I need to prove, or there is some conflict between what was being said here and the witness I spoke to, or other things that say, you know what, this is not going to meet the burden that we have, so we are not going to file this. And there's also just the times where, oops, sorry, we made a mistake and arrested the wrong person. This often happens in domestic violence cases. There's an argument between two people. The person who's actually the victim ends up being arrested. Under this new priority, that victim is now can get charged, can get placed in removal proceedings because they were arrested for something that was not even filed. What's happening next? What's the trend? We're seeing that there's, with the Department of Homeland Security, memos that were released the last couple of weeks that there's a trend to remove due process. Due process is bringing people the ability to go through different steps in order to get access to the judicial system. All people have the right to a hearing in front of an immigration judge before being removed from the country as of right now, except undocumented people that are stopped at the border. They can be placed in what's called expedited removal. That's happened under the Obama administration. So if a person was stopped at the border, they would say, sorry, can't come in, let's get your fingerprints, you have been deported. That stays in their record and it has a certain impact of being able to get removed before. This can be a problem because now these are people getting reviewed to see if maybe they are being persecuted in their home countries or they are victims of crimes that make them eligible for certain relief. Although that we are supposed to be reviewed for that. The memos have stated that there might be an increase of that kind of expedited removal, not only at the border, but inside of the country. We have not seen that yet, but people who are undocumented will have to show proof that they've been in the country for at least 2 years before they will be able to have certain forms of relief and not just immediately get taken from where they live into a country where they may have entered from. Okay, so the executive order also declares that they want to increase all the potential of local law enforcement's ability to exercise federal immigration law. And declare that the policy of the executive branch to cooperate fully with states and localities to do so, to expand its priorities, monitor the programs, and do detention. And it authorized the Department of Homeland Security to identify which places are sanctuary jurisdictions and to deny them federal grants, although they do not define what a sanctuary is. It also directs the Secretary of the Department of Homeland Security to immediately take appropriate action to agree with states and local officials to enter what's the 287G contract. Okay, so what are these? What it does is inside the jail it says, okay, you. We're going to give the 6 of you training. You are now Sonoma County Sheriffs and you are deputies of the federal government. So when a person gets booked in, you are doing 2 jobs. You're asking what you need to do for the sheriff, and you're also doing for the federal government. These were extremely problematic. People were not getting their Fifth Amendment rights and access, and people were also being targeted based on surname. And it also increased a number. While I was working in Riverside, I had 7 U.S. citizens with ICE holds because of this type of program. As of right now in California, there is only 1 county that has a 287G contract. And the benefit to the county is that they'll get a little bit of money to have people sit in their jail. So the only county that currently has one is Orange County. But when I was doing this back in 2012, there were many more. It's been a very active community resurgence against them that has expelled the 287Gs out of the state of California. The executive order also says it's going to be collecting certain data and then presenting it. So it applies, it's saying that any immigrant person, any person that has not a U.S. citizen that commits a crime is going to be listed on these lists and provided. It applies to non-citizens in state custody, including pretrial custody, who has a prior conviction. So, in this country, we are supposed to be innocent until proven guilty, right? This list would not be showing that. Similar lists were done under the Third Reich as well, targeting the Jewish community. So what other priorities have there been? Building a border wall, ending the flow of Syrian refugees to the United States, and extreme vetting of visa holders from 6 Muslim countries. It was 7 as of yesterday. It is 6, considering that our involvement in Iraq, there has been a change in be denying people to coming in from Iraq. Although the visa process, if you know anybody who is a student here on a visa, ask them if it was easy or not. It's a very long process. So what may happen? These are things that we don't know, right? But some things that have been said in certain rhetoric. Aggressive criminalization, prosecution of people who are active in organizations and citizens who live, immigrants who live in undocumented family members and others as well. So how many are aware of the Free Danny campaign? Anybody? Okay. Daniela is a person who had DACA status, and she had her DACA status and her parents were removed from the country. She became an activist, talking about what it meant to her to have her parents separated from her. And last week, she had her DACA status that expired, and we'll go a little bit into about DACA. She was afraid of renewing that DACA status because of the very high costs and losing that money. And it's about $500 to apply, and she's a student, like all of you, and $500 as a student is a lot. And so she had a little bit of lapse. What happened to Danny was that she was at an event where she spoke about her personal experience and what it was to be a child of someone whose parents had been removed from the country. When driving home from that event, she was then taken into custody. So we have seen a little bit of this as well. As an activist, she got targeted. So what does this mean for deferred action for childhood arrivals? It was part of the campaign to end DACA, and there has been some leaked memos saying that it would be ended as well, but it hasn't been ended. There is some risk, though, because people with deferred who are already have their DACA status, the federal government knows where they are. And let me break this down, because this might be a foreign concept. The district attorney could one day say, you know what, drunken publics take way too much time and money out of the county for me to be spending all my time on prosecuting them. I'd rather actually make sure that people who are drunken public get services, because that's going to be better for our community than all the money that's spent to stop people and incarcerate them for being drunk on the street. Okay? Maybe especially around the Katati area on a Friday night. So they might just say, you know what, we're not going to prosecute that anymore. It's their prosecutorial discretion not to. Likewise, the president is the prosecutor, the head of the executive branch, who can say this is not a priority for us. We are not going to use our resources. And the president said 16-year-olds to 30-year-olds who were brought in here during this period of time is not, who are contributing to our society, who have gone to school here, who have made this place their home, is not worth our time and money. So we're going to allow them to be here and work. Well, they have all of that data inside of databases, all of their information for people who got this form of relief. And so right now, people who have their status have not lost it, and people are renewing it, but they do so at a risk. They don't know how long this is going to last. And for those individuals who have not applied but may be eligible, it's a risk that they'll be giving their information and outing themselves to the federal government. Okay, so that was fun. Let's go through state laws. As a result of the political climate, some states have been making certain laws to try to protect immigrants inside of their borders. They have done some legislation that increases, or alternatively, they've increased the level of interaction between the federal government and their local agencies. prior to this, in California, there already was a passing and signing of the Truth Act by Governor Brown. TRUTH stands for Transparent Review of Unjust Transfers Holds Act. This was signed by Governor Brown on September 29th and became effective on January 1st. It has to do with the fact that not all jails were being very open about what their relationship was with the federal government. And so now it's required that when those documents, those notifications go inside of a file from a person in jail, that the person knows, because they didn't know that before. They would just do their case, and the next thing they know, they were being shipped off. But now, the person who has that in their file, the non-citizen that has that in their file, gets to know. And so do I, as an attorney for a person who's a non-citizen. I get to know that this is in there, and I get to advise them, I get to talk to them, and I get to see, is this appropriately placed? Was this a U.S. citizen or not? Did they have the boxes checked that were supposed to be checked? Is this person being held longer than they're supposed to? That's my little reminder to let me know I need to shut up pretty quick, so I will. Well, also, they need to let the attorneys know if they decided to participate in the program of notification and they're going to call the ICE agents, they have to let the defense attorney know as well. So, person gets arrested, ICE comes over with a piece of paper, and now it's time for that person to end their time inside the jail. They've been there for a day, for two, and the jail wants to call ICE. They get to call ICE, but they also have to send my office a piece of paper saying that they're calling ICE and what time they're releasing that person. The other thing that this law does is it requires written consent from a person in custody before they have a conversation with an ICE agent. There is not a Fifth Amendment right or Miranda right in immigration court. And so what was happening is that jails were allowing for ICE to come over and go into interview booths, and the person wouldn't know if that's their attorney, if that's a probation officer, of who this person was. And we'd start giving them questions. And people were ending up providing information that was assisting in their own removal from their country, but not necessarily helping with things like asylum. So that changed that. And it has to be in writing what the purpose of the interview is for, and in the language of the person that's receiving the document. English, Spanish, Chinese, Tagalog, Vietnamese, and Korean are required. The others are not. So the other thing that this law did is that it requires that if a county agency or if any agency is going to be participating in the notification process, they have to give a community forum of all with all the dates and interactions and data between ICE and the jail. And that will start in 2018. I'm going to just let that slide be there for reference. There are other rights that are allowable. Some of these things that I think are really important, I'm just going to briefly touch. California has a pending legislation called SB 54. It basically is saying we are not going to have any correspondence with ICE. We're not going to use our state jails, prisons, Social Security, DMV, anybody who is part of the state government or local government use any of its resources to cooperate or contact or speak with ICE. There has been some amendments that are now going through the pipeline that says for people who are serious or violent felonies that they would participate. And dignity, not detention, is for ending privatization of detention centers. And SB 3 would be to have, right now in the state of California, there's only 7 people that do, or 7 counties that have somebody like me inside of their public defender's office. It's pretty hard to know all of the California criminal law and then all of the federal immigration law. This would help make sure that public defenders and criminal defense attorneys are actually doing their Sixth Amendment job of advising people the right way. And that should be SB 6, sorry, not SB 3. and flip those around. So the Public Defender Act and the Due Process for All would actually, as I said, you don't have a right to an attorney in immigration court. This would give you a right to an attorney if you are a resident of California, you've stayed and lived in California, you would get an attorney with you in proceedings. So with that, I'm just going to stop. There is some slides that you can review on your own. I'm sure Professor wouldn't mind handing them out about some of the things that are happening with Sanctuary and some of the things that you can do with Sanctuary. There are some resources. I'm just going to briefly talk about Sanctuary just basically means not having cooperation with ICE. We can't stop ICE from coming into a city. It's not possible. And so when we talk about sanctuary cities or counties that are states, that's what we're talking about. The only places that you can actually do what's considered sanctuary are private businesses or private places like homes, schools, things that can actually close its doors. Colleges and JC is sanctuary or safe haven location. I'm not sure if Sonoma is. You can also contact these local people, the sheriff, district attorney, and chief of police to see what their policies are with cooperation. And I've listed a bunch of different information and resources for you so that you can look a little bit more on this issue. And with that, I'll take any questions. Oh goodness, okay, we'll go over here.
Why do you think the policies are different between immigration cases and normal cases? So you mentioned like immigration, they're not given to an attorney or like a right to an attorney, or they're not given like bail bonds or like able to get bond. Why do you think there's a difference between those two?
The short answer to that is the distinction between criminal cases is supposed to be a denial of liberty, and civil is not supposed to be a denial of liberty. And there's the theory and the reality. So civil is just supposed to be a small time to figure out where to go. And that's why they're not afforded the same rights. It's not supposed to be a punishment. Yeah.
My question for you is, do you believe that those who are undocumented and haven't been involved in like serious criminal activities have a right to stay in this country, or should they be deported? So people that have committed murders, rapists, or drug dealers, do you think they have a right to stay here, or should they?
So it's not really an issue. As a criminal defense attorney and as an employee of the county, my personal opinion doesn't really matter a whole lot. But what does matter is that person being afforded with the same rights as everybody else. The difference is, as a U.S. citizen, you commit a crime, and you're going to have to do some punishment. As a non-U.S. citizen, you commit a crime, and you're going to have to do a punishment, and then you're going to have to do another one. So the question is, do you think that is fair? Next question right here.
So locally, Sonoma County has the Chiefs Association and the sheriff have said they don't cooperate with ICE. Are you seeing different in your office?
No, it's not.
I mean,
It's
it
not
says
my
that they
office.
don't collaborate. Well, it says they don't collaborate with them, and the sheriff has said the jail, or the
So
sheriff's department is
let's
not
be a little
cooperating with
clear.
ICE.
The sheriff has says he does not participate in ICE holds. That is true, because you just learned that ICE holds are illegal. So he does not participate in an
But he's doing
illegal
the
event,
notifications.
but he does participate in ICE notifications. And just to be clear, there are two different levels of the sheriff. There's the patrol section.
Yeah.
They won't actively call ICE on patrol. It's only within the confines of the jail.
For documented and undocumented citizens, what constitutes a crime? Does it go all the way from like a parking ticket to murder?
So under the new executive order, is that what you're referring to?
Yeah.
Yeah, so anything that could, it's what's under the penal code. So, what's a good one? It can be a crime to spit on the ground. There's municipal crimes that you can be charged with for that. Having, like, I literally represented a hoarder before. So it was a municipal violation, misdemeanor, and my client had like so much stuff, you could see it from Google Maps. So that's a crime. So yes, it under the new executive order, it's anything that's a misdemeanor and up. So, yes.
Because like Danny and the Delta in the west, like Arizona versus the US, like case not being allowed to like stop people, like when they're just like on suspicion of like if they're illegal or whatever. Like why did she get stopped when she was doing like her event and like why did she get in trouble?
Okay, so let's separate those two things. So in Danny's situation, she had already publicly stated that her parents had been removed. Now, it wasn't local law enforcement doing the stop. If the federal immigration has reason to believe and reasonable suspicion that she's in violation of her status, and they may have been more actively checking to see when her DACA expired, then they do have a basis to arrest her. Does that make sense?
Yeah.
Okay. And I know people are ready to get out, so I'll take two more. Right here.
Just really recently, the Fox 5 Sheriff's Departments found a way to counter what I get most of the departments in California are upholding sanctuary support, and just this morning, the 5 Sheriff's Departments have found a way to oppose it and say that it's actually not a good idea to support sanctuary non-cooperation because I thought that was interesting.
Yeah, so the data is pretty extensive on how, and I do have some resources that are listed for you there, but the data is pretty extensive that sanctuary communities are actually safer. Let me tell you why. How many of you read about the transgendered woman in El Paso who went to get a restraining order on her boyfriend and was picked up in domestic violence court? Okay. When people are afraid that their immigration status, and it was reported that it was actually the abusing boyfriend that called ICE on her. When people are afraid that if I call the police, they're going to pick me up and take me away, they won't report. So there's more immunity and impunity of actions that are happening. People who are victims of crime are not going to report. People who are witnesses of crime are not going to participate in the judicial system. And then it also has an economic impact on the surrounding areas where people are afraid to have interactions, don't buy things, don't go out of their homes. And the statistics have been showing that it actually creates a safer community when there are sanctuary cities and states. Yes?
In the new administration, do you see there being a chance of more DUI stops just as a means of catching more people without documentation?
Now, that's a really interesting question because even under the Obama administration, similar tactics were used. DUI checks in the state of California have to be announced ahead of time, and they can't be by schools or churches. There's certain limitations. But there was cooperation with some local agencies with ICE. They happened to be present. Could that return? Yes. It was reported out of the county where I used to work in Riverside, a similar check stop that doesn't need to have those limitations. Checking to see if people have car seats were being done at school, and parents and children were being ripped apart at their school. Because they would check to see if the car seat was right, see the parent didn't have a license, and then Border Patrol happened to be sitting there next to the sheriff at the same time.
Okay. I think we have time.
Thank you.
Thank you.